you been given any indication whether legal action will be taken against the state?
Well, the initial view that was put to me by Ms Donegan's lawyers, the ALS, was that that action was likely. I don't know whether or not that position will change by virtue of this payment, which is obviously a sizable amount of money. And the legal action is again a very complicated matter. It may or may not be successful. If it were successful, a quantum of damages may or may not be greater than that which has been nominated here. But in any event, what we have said is that if this does not bring finality for Ms Donegan and her family, and the only way in which that can be achieved, given what has happened with the criminal prosecution, is through a civil action, then we don't want to stand in the way of Ms Donegan from embarking on that action. What we have said is that if that action is successful, then the amount of this ex gratia payment would have to be deducted from the damages claim, but otherwise there are no strings attached.
The payment to the children, which is going to the public trustee to be administered for their benefit, is there a reason why it's gone to the public trustee instead of to their mother as their living guardian?
Well, look, I mean, it could have occurred either way. The public trustee is a very reputable government instrumentality who maintains and manages trusts of this type all of the time. In actual fact, it was a view taken by my office and ultimately the government that that was a way in which we could further assist the family by, in effect, having a very reputable government instrumentality manage those trusts.
Is that paternalistic though, when you've done that for a white family?
Well, look, there are different views about whether or not this is too prescriptive or not prescriptive enough. What we've tried to do is strike a balance, and ultimately what we have looked at is how do we promote and advance the welfare of Ms Donegan and her children, and whatever views people may have, the view has been reached by this government that this is the best way to promote the welfare of Ms Donegan and her children.
Did the ALS agree with, I mean, that was a negotiation with the ALS as well?
What occurred there was that the negotiation with the ALS was largely about the quantum. There were some views put about the way in which the monies should be managed or transferred to the family. You'll have to ask the ALS for their precise views about what it is that we have said is going to be the manner in which the monies will change hands. But the situation is this, that the governor will be faced with an assent to this matter. When that occurs, the monies will become available, and they'll be coming available in the fashion in which I've described to you. And that is a decision of government. So the negotiations went so far. You'll need to direct that question, I think, to the ALS. But let me read out again that what we have done as a government is make a decision as to how to best promote and maintain for a very long time the welfare of Ms Donegan and her family.
Is he the father of all those kids?
Well, my understanding and the advice from
The legal guardian?
my understanding and the advice from the ALS is that he was the breadwinner for the family, and that was his family.
And did you take the Mallard payment into account when considering the payment to his family in terms of, I think it was 3.25 million?
Well, that was a very large payment of money, and looking at international and domestic precedents, it was as high as any that we could find. This is a very, very similar amount of money. There is no real comparison because the situations are so very, very different. But what I would say is that the three things that I nominated to you, we took into account in this matter, were also things that we took into account in the matter that you've described. And that is what type of action may have been brought against the state and what was its prospects of success. What did people submitting on behalf of the person think was a fair and reasonable amount? But finally, and most importantly, what amount of money is going to appropriately show contrition by the present government for the failures of the previous government, and then has put the family in a position where they have a real future.
Is that also the difference, I guess, in the Mallard case there's evidence of corruption and in this case it's more negligence?
Well, I think that the question that you raise goes to the point that it is impossible to compare the two matters in terms of their substance. But what we have said is in outcome, what we've tried to do is put the late Mr Ward's family in a position where their welfare well into the future, if not for the rest of their life, is guaranteed. And in a way, that was very much central to the calculus that we undertook with respect to the Mallard matter.
What advice have you had in terms of the success of any legal action against the state and what amount that could be?
Yeah, this money is given over without admission of legal liability, although it is meant to show contrition, deep remorse for what has occurred. but it is not meant to establish legal liability. I obviously won't be able to give out advice that I've received about the prospects of success or otherwise, because it may be that there is litigation into the future. But let me say here that that was a matter that was given some consideration.
Have you had any indication as to the legal action that may or may not take place?
No, I haven't. I mean, really, that's a matter for Ms Donegan and her legal representative.
Was Mr Mallard's payment given to the public trustee?
No.
With that money, the extra money aside from a property being purchased and the payments to the family, you said that would also, Ms Donegan's money would also go into a trust account with a bank. Is that her decision and the ALS's advice, or is that something the government imposed on her?
No, it's not a condition that we've imposed, but let me say that I think that Ms Donegan's legal representatives, like the government, have well and truly her best interests at heart. And what we have said is that, based on the conversations that we have had with Ms Donegan's legal representatives, we have certain expectations that things will be done that have been said will be done. And we've taken that on face value, and it seems to me an eminently sensible way in which to approach the monies. Of course, had further trust been created by the government, then that would have been overly prescriptive on one sense, because it would have prevented Ms Donegan from taking a lump sum amount and buying a property. But I think that the arrangements that have been entered into are in the best interests of the family.
And just
once
with those
they're
children,
adult-
when they turn 18, you said
Once
they
they're
could
adults,
apply,
it's a question.
or
They
do
can
they
actually-
automatically get it? Do they automatically, once they're 18, does that trust situation continue, or are they assumed to then be
The
an adult?
option is
who
an
can-
adult to
No,
dissolve it.
the trust continues, but there is an option to dissolve.
You had to go, like, obviously this happened under Labor's watch, they've been in power for 7 years or something, and hadn't done much in relation to prison transport services. But can you seriously say that it would have been a priority for any state government to put money into prisoner transport services, because corrective services is never a priority area for spending? If it wasn't for this tragedy, there wouldn't have been this wake-up call.
Well, I mean, the present government, the Liberal National Government, spent $656 million on prison infrastructure. The present Liberal National Government will have the entire vehicle fleet replaced by December of this year. And the history of this matter is that, notwithstanding some of the public comments that are made by present parliamentary members of the Australian Labor Party, they were warned on successive occasions that the vehicle fleet was not fit for the transport of human beings, and despite having an enormous budget surplus at the time, they declined through a cabinet decision to spend money to provide for a prisoner transport vehicle fleet which was fit to transport human beings in. And frankly, I, for one, am tired of hearing ALP parliamentary members enter into this debate in circumstances where they have no right.
Have you personally delivered this news to the news of the amount to Mr Ward's family, or is it just simply through the ALS?
Well, the thing is that I've not met with Mr Ward's family, and the reason why is that, acting in a legal capacity, I am prevented, according to practice rules, to meet with the clients of another lawyer. Ms Donegan is the client of the ALS, and she's being served for it. So what I have done is continued my communications through the ALS. I wrote to them after the cabinet decision on Monday, and in fact the information that I've given to you about what is happening is very closely aligned with the letter that I've sent to the ALS.
The ALP can't make a financial award, obviously, because they're not in government, but should they be coming out today and making the same unequivocal and sincere apology to Mr Ward's family, at least?
Well, in my view, yes. Many statements have been made by many members of the Parliamentary Labor Party. Very few of them have been an acknowledgement of wrongdoing.
That $110,000 that you think she's going to give to the extended family, about that, is that a condition of the payment that she can only give that amount?
No, it's not a condition. And again, we've tried to strike that balance between being overly prescriptive, but also ensuring arrangements that will make this money last for the long-term welfare of Ms Donegan and her children. What it is, as I understand it, Ms Donegan has expressed to her legal representatives that she wishes to make these payments. Advice has been given to her. There is an expectation on the part of government that those payments will be at about the level of $110,000, and that after they are made, her money, which we pay over in a lump sum, will go into a trust.
What then happens for the future of contractors who do this prison transport service? Do you want to see all of that taken back by the state government, that responsibility?
I had also a very long press conference on this not long ago, but the answer to that question is this.
In light of today?
This contract comes up again in the middle of next year. We have said that we will go out and test the market, but What we are looking to do is test the market for some level of private sector delivery, but it is a level less than what occurred under the previous Labor government. What occurred in this instance was a complete failure of government. What we are trying to do is look at whether or not the market can properly deliver services in a decreased way, and what we want to leave out of private sector and bring into the public sector is what is known as ad hoc prisoner transports. Many of the problems arise in the types of prisoner transports that involve transportation of prisoner from prison to hospital, from prison to funeral, from regional and remote lockups. And what we're trying to do is make sure that if the market is able to safely provide prisoner transport, it is in the areas that they provide transport well.
Is this one of the highest payments in Australia?
To our knowledge, it is. We went through this with the previous payment of 3.25 to Mr Mallard, and we saw at that time that payments at about the 3 to 3.2 level were well and truly at the upper echelons of ex gratia payments.
In the country?
In the country and indeed in all Commonwealth countries.
Can you rule out G4S though getting any sort of contract in the future?
Look, the private tender is a matter that's conducted according to tender rules. Nothing prevents G4S from applying to any private tender, but I mean, it is a matter of common sense that part of the tender process is a consideration of the previous record, and that has not been a good.
Do you think G4S could be doing anything proactive or constructive towards an apology towards the family as well, given that at this point they've not been held accountable in any sense at all, either through punishment of their contract except for a $100,000 fine and no criminal charges? Well,
look, that's a matter for ultimately for G4S, but if I had a personal view about it, my answer would be yes. This is meant to show contrition, remorse for the failure of the previous government, and it wasn't merely government failure, but ultimately here, as the coroner pointed out, no government through contracting can abrogate its duty of care to people who come into contact with that government. And so ultimately, G4S's failure was the failure of the previous government, and it is one that we are now apologising for, one that we are now trying to do our best to set right.
I know you won't detail the specifics about legal advice, but was it roughly that if damages were successful, it would be about this 300 million mark?
I won't go into it, but let me say again that a 3.2 million figure, by international precedents, by Australian precedents, in consideration of what may occur in civil litigation, is a generous amount, and so it should be.